So our next two speakers, Dora Senkow and Tom Wydra, are from the Connecticut Labor Department, and they are going to talk about the top 5 wage and hour mistakes that they see from employers. Or that was their assignment, at least. They claim that there are so many mistakes that employers make. They maybe couldn't keep that to 5, so we'll see. Mr. Wydra is the director of the Wage and Workplace Standards Division, and Ms. Senkow investigates and audits all of you people. So pay attention to what they say, because this is going to give you a sense of what the investigators are actually looking for when they show up at your door. Okay, so despite that description, please welcome Dora Senkow and Tom Wydra.
Thank you very much, Diane. We are grateful for the invitation from CBIA to be here, and certainly grateful it's such a large audience. We prefer to educate rather than to enforce, believe it or not, aside from what was said at the outset. Dora is the real expert here. I joined the department 3 years ago. She's been here 18 or 19 years. She's a wage and hour expert. So I suppose without further ado, unless you want to say anything at the outset, Dora.
You just gave my age away. Thank you, Tom.
I think we're going to get to Q&A at the end of the slideshow. Okay.
Hey, Tom, I don't know if this was a subliminal message to our audience, but your phone number isn't actually on there.
Oh.
So I'm looking at my phone numbers. It's on there, right? So, and Dora's is noticeably absent. Dora must have had something to do with that, I suspect. But her email is there.
You can just call Tom. It's fine.
All right, so we'll get into enforcement functions. Oh, minimum wage. Let's walk our way through this. As I think most or all of you know, we enforce a myriad of labor laws here in Connecticut. It's probably a state with as many or more state laws as any state in the union. And again, I'm sure most of you are fully aware of that. So we start with a complaint.
So the question before that slide asked if you were ready for an audit. You will be after today, I hope. So any questions, please make sure that you reach out to us. The majority of the complaints usually come from former employees, okay? So when we say that we refer to an employee who is leaving you and is really pissed off at you when they're leaving, which happens a lot, I'm sure you guys are aware. So you want to make sure you cover yourself in many areas, such as making sure you're paying them properly, especially on their last paycheck. Okay? You can go on. The best ways to communicate is obviously the hiring agreement. A lot of employers claim to not realize you need a hiring agreement. You need something in writing that states their hourly rate that they are hired and the position that you're offering. You want to make sure that you communicate with your employee at time of evaluation and at the time of separation.
I went to an employer with Dora a couple of years ago, and this was an employer who did not have any hiring agreements in place. And Dora said to him, we don't care if it's written on a napkin and archived. Just have something. I'm not advocating for writing a hiring agreement on a napkin, but it sticks in my mind.
We get a lot of complaints that employees will say, oh, I was offered $20 an hour, when in reality, the employer really wanted to just pay them the minimum wage. So you want to make sure you communicate those specific information details to these employees before they even begin working for you. The investigation. any and all books, registers, payrolls, and other records of such employer that in any way pertain to or have a bearing upon the question of wages of any such person. What does that mean? It means pretty much any records that pertain to the payment of wages for that employee. Any bonus checks, records, time records, wage records, email, texts that will say to you, oh, I'm taking the day off, anything that's going to show us the time that they're taking off or the time that they're working. It's something you want to keep.
On the premise.
On the premises for a period of 3 years.
Unless you get permission from us to archive them elsewhere.
Okay, the standard in our office is the records need to be true and accurate. So let's explain to you what a time record is, what we would consider to be a true and accurate record. A schedule would not be a true and accurate record. Anybody can do a schedule, right? Attendance records, they're not always accurate. Computer log on and off, that's just someone logging into their computer. That's not accurate. That's not telling me the time that someone's starting. Exemption records as is tell us when you're not here. No. Assume start, you never want to assume when someone's starting or ending their day, ever. It has to be true and accurate. That means someone is actually punching in and punching out. That's including for their lunch. So if I'm coming in and as an employer you're saying, oh, you don't have to punch in just now, just wait until you start working. No, you're allowing me to stay in the business. You're allowing me to enter the business. You have to punch in. That is working time. The moment you're allowed an employee to come into the business and sit at their desk, whether they're actually physically doing work is irrelevant. The fact that you allow them to be there is what we will consider the time to start.
Just one note on that, too. Waiting, employees who are waiting at a time clock to punch in, that's compensable time. Some of the larger employers we deal with, we get claims from people who, on a daily basis, they wait 15 to 20 minutes because there's a mad rush to the time clock. That is compensable time.
Oh, the rounding rules. Yes. You're not required, well, the law says, yes, you can round, but we don't require. You can pay to the minute, you can round to the nearest quarter hour, as long as it's consistent. That's all we ask. It has to be consistent and accurate through the time records, through the weekly totals, to the wage records, and the weekly totals on the wage records. If an employer chooses a method other than the 15-minute rule, it must be consistently applied to both in and out time entries and be increments of no greater than 15 minutes. That's what I just said, the rounding to the nearest quarter hour. They call it the 8-minute rule, 7.5-minute rule, quarter-hour rule, whatever you call it, as long as the 15-minute rule, that's what the law says.
My 16-year-old daughter entered the workforce 3 months ago, and she was actually taught this in orientation, so I was very pleased.
Oh, nice. Examples using a minute clock. These are just a few examples. Very basic rounding. I'm sure you guys are all aware of this rounding. Nowadays, computers does it for you. The clocks that these guys are punching in, they're doing it for you. A lot of our laws in the rounding is very antiquated, but nowadays computers do all of this for you. Just got to make sure that it's done correctly according to what the law requires you to have it.
And consistency is crucial.
Consistency, yes.
More examples.
Yes. Time card requirements. Each work period must be defined by in and out time entries. That's really more specific to your lunch times. That is one of our biggest issues. Employers just assume that an employee will be taking their lunch time, and they will do an automatic deduction for the day or total amount for the week. We don't allow that. They have to punch in and out. That's what an accurate record will be. In and outs for lunch, in and out when they're in and out, in the morning and in the afternoon.
And Dora, just for the people that are connected remotely, can you speak up a little bit?
Sure.
Sure.
Daily total of hours, that's actually in the statute, so you do have to have daily and weekly total of hours. Anything else you would like to add, Tom?
No, the meal period one is something that seems to have popped up much more frequently. I don't know if the pandemic had an impact on that. Oh, I know it did in some industries. But the four-punch rule is the four-punch rule. Mm-hmm. And we know employers have folks who don't come to the office. They go right to a work site, or they travel for work and they can't get to a punch clock, at the office and then go back, 60 miles away or whatever. And so you have to make accommodations for that. Employees can sign off at the end of a pay period that they did in fact receive their their meal period on each particular day.
So just a word of advice. I know there's many different industries out there, and many times an actual clock for them to punch in is not available. A spreadsheet that they can take with them and actually put in their time. They can call in their time to your secretary. Just have them sign it either at the end of the day or at the end of the week. A lot of employers don't realize how important a signature in those time cards will make. It could many times make or break a case. Maybe I shouldn't be saying that, but a signature is very important. It's what would tell us that the person that signed that timesheet knew what they were signing, and in our testing that is true and accurate on that time. Like I mentioned, it could be handwritten time cards, mechanically punched time cards, computerized systems. We don't see handwritten cards like we used to anymore. A lot of it is computerized. So giving them a password to go into those computers and to actually have a login information, that alone will be more of enough for us to know that they're going in there themselves to put in their time. However, if there are any changes in those time cards by management, by HR, those need to be added in a note in those time cards. And they have to have the employee's initials that they were aware of that change.
That's such an important point. I met with an employer the other day, and the time sheets were all marked up by the employer. No initials from the employee to verify that the hours were different than what the time clock had shown us. And so that was a big problem for the employer.
I love it when an employer will give me records of actual bunch of in and outs from an employee, but then they're crossing it out. They're having oh no, this person punched in at 7:30, but let's cross it out to 8 o'clock. So you don't want to have those kind of time records. It's not true and accurate. If you do have to make any changes, have them initial it or document it in some way.
These are just some of the pros and cons that we've witnessed over the years. Again, they all have their pros and cons.
Yeah.
I don't know, should we go through each one of these, Dora?
No, but I do want to point out, with the time cards, especially computerized time cards, take the time to communicate with your workers, to explain to them how the rounding works, what the computer is doing with their time. Because we do get complaints from employees that will say, oh, they shorted me half an hour every day, and they don't understand. Okay, so you want to be able to communicate and explain what's happening to their time and what the system does to their time.
And remember that under the law, employers, you have total responsibility for maintaining the true and accurate records.
Yes. It's not your, your accountant's responsibility, it's not your attorney's responsibility. It's the employer's responsibility to provide us with true and accurate records. One more thing I wanted to add to that. I get a lot of employers that say to me, oh, the payroll company did that. The payroll company is the one that did the error. No. We're not going to go after the payroll company. The law says you as the employer are responsible to keep true and accurate records, and therefore you are the one that will get the fines, not the payroll company.
It sounds like someone tried that in the room.
Exemptions. Ooh, those are the good ones. Okay, so there are a couple of exemptions, okay? We have professional, administrative, and what's the third one?
Executive.
Executive. So if they truly fall under those exemptions, they're exempt from minimum wage, record keeping. But you want to make sure they're exempt before you say, oh, we don't need time records for this person. Because guess what? Your opinion on someone being exempt could be different than what we will say is exempt. And therefore, now you're violating record keeping laws and minimum wage, overtime, and other things. So you want to make sure you understand what each exemption is, what it needs to have in order to be an exempt employee. It's not just a title. It's never just a title, actually. So you want to look at their day-to-day duties.
Yeah, it's not fancy titles. It's not bulked up job descriptions where you build in everything that you would think would be make somebody exempt. It is, after all, the job duties, whatever's done day to day.
The overtime. Okay, so the one thing I always get, okay, my bookkeeper is exempt because I put her on a salary. A bookkeeper is not an exempt employee, so therefore, if she works overtime, there's overtime due. A time and a half, dividing it by that salary, plain and simple. So that's one of the misconceptions. Not all salary employees are exempt from overtime and minimum wage and record keeping. I love that one. So just because I sign and agree to be exempt does not make me exempt. Okay, so that's like you saying, you can pay me below minimum wage, I'll sign it, and you're good. No. You have to pay people properly, and just because they're signing something does not waive their right to pay minimum wage and overtime.
So we went through that.
So, we talked about the duties. It's always about the duties. The salary, of course, it matters, but the duty is the tricky part. You have to concentrate on what they're doing every day, and their daily duties have to be the same as your job description. I hope that makes sense, because it doesn't always add up. I can be doing 20 extra things that's not in the job description. So I hope if you take anything from our conversation today is that you can have a better understanding that you need to really look at what an employee does day to day versus what it says on their job description. And then analyze both and make the final determination if they're going to fall under one of the exemptions.
Dora had a case that dates back, I think, a bunch of years, but she testified last year in court. The claimant was a sous chef, which sounds like a very fancy title. I suppose it might be. It probably is. But everything that the person was doing on a day-to-day basis had nothing to do with meeting the duties test. It's a really good case that we were able to win in court.
Okay, so the employee must have a primary duty of management for, this is the executive, correct? Yes. The primary duty is management. You've got to be supervising 2 or more people. If you have a manager in a store, okay? Now, I'm not going to go in detail on all of them, but I'll just give you a brief example. If you have a manager in a store, and this manager has 5 people on a regular basis, but then, off season, maybe you have just the manager and 1 person in the store. Would that person be exempt during that time period? No, because they fell out of that exemption when there was no other employees with them in that store. That's just plain and simple. They have to be supervising 2 or more people at one time, okay? That's the one thing we'll always look at in order to determine the exemption. Customarily and regularly directing work, like I just said. Hiring and firing, yes. They have to at least be able to recommend to hire and fire. Obviously, in many industries, it's the decision of the owner, but in an executive position, you should have at least a say in firing and hiring someone.
And some of your operations may be fluid, may be based on season and so forth, so that I'm glad Dora mentioned the 2 or more. You should be mindful of that you might have an employee that during parts of the year is exempt and parts of the year is not exempt.
Mm-hmm. Oh, inspection foreman. Okay.
Just some
so
examples.
There's just examples of someone we would say they're exempt under the executive capacity. Typical red flags that we normally see that we have to always check: assistant managers, anything assistant, assistant foreman, like I said, anything assistant. You're assisting someone, right, that's already exempt. The fact that you would think that the assistant to the exempt person will also be exempt is a little bit of a stretch, so we will always look at that and make sure that that person is falling under the exemptions. The administrative exemption. An employee must have a primary duty of the performance of office or non-manual work directly related to management, policies, or general business operations of the employer or the employer's customers. This work must include the exercise of discretion and independent judgment in its performance. We get a lot of that, administrative exemptions. That is the tricky exemption because that's the one we really have to focus on all the day-to-day activities to make a final determination. So,
definitely the most difficult of the 3
yes,
to navigate.
the most difficult out of all 3. Some examples of the occupations typically found to be administrative exempt are company controllers, human resource director, chief financial officer, and chief executive officer.
And then you have your red flag titles. Again, building into the title to try to insulate from what would otherwise be a non-exempt employee.
Right. The bookkeeper is one of the most common. We usually get a lot of employers to say, oh, she's my bookkeeper, she's exempt. No, she's not exempt. The professional exemption. The employee must have a primary duty of the performance of work of an advanced type in field of science or learning customarily acquired by a prolonged course of intellectual instruction and study. We will say 4-year degree. You know, some of the examples we put in here are accountants, architects, doctors, attorneys, engineers. We typically don't get complaints from them.
And some in certain nursing occupations as well.
Right.
But others not, in terms of nursing. That's when we get lately more frequently.
Yeah. Salary test. In order to be exempt, an employee must meet the duties test, must also be paid on a salary basis. Okay, so the salary needs to be consistent throughout their employment, with some exemptions. Okay, but generally the same salary every week. It can be, oh, you were out sick today, or you just had a personal day today, we're going to pay you less. They have to be paid every week, the same week. Okay? Yeah, doesn't matter if they meet all the criteria to be exempt. If you decided to pay this person different salary every week, or if the salary is fluctuating when we look at your records, you lose the exemption. You can tell me they're a doctor. If you're paying a doctor an hourly rate, guess what? You're going to owe them overtime. A salary is a consistent sum of money given by an employee to an employee, each pay period, regardless of the time worked, quality of work, and quantity of work. Just keep that in mind. I just had a case a couple of days ago. The employee fell asleep for a little bit during her shift. And the employer wanted to not pay her for the day. And I said, oh, she was there. The quality of the work wasn't there, but she was physically there. Nobody sent her home. You should have woken her up and sent her home, but you didn't. So because you kept her there, now you have to pay her for the day, whether it was sleeping or not. Okay.
That's an amazing story. Truly. Maybe it's only in America, I don't know. But word of sort of caution with the minimum salary, that's the Connecticut number, Connecticut numbers, and they're dated. The federal numbers are much higher now. So, be aware of that. We would refer likely, and if an employee made a claim, and it was about the salary, it was about the exemption and so forth, we would likely, educate them on seeking out an investigation by the U.S. Department of Labor, because again, the number now is in the high $30,000 range, if I'm not mistaken. That's not something we enforce, obviously. We enforce our numbers.
That's the long test. That's the phone to the feds.
I think you went over this too.
Mm-hmm. So these are some of the conditions of the deductions. The salary payment for all first and last weeks of an employment can be prorated. A lot of employers don't realize that, but the first week and the last week, you can prorate those weeks, okay? So you can just calculate what you're offering them for salary on that first week and come up with an hourly rate for the few days that they did work the first week, and the same for the last week. Whole day deductions in salary may be made if the employee is absent for personal reasons other than sickness or accident. So some of the criteria you have to follow on some of these deductions for the salary are such as that. There's only certain situations when we were allowed the deductions. But a lot of it is covered through bona fide benefit plans that employers offer, such as sick time, vacation time, personal time. So a lot of that we don't see a lot, but it does happen. But don't see it because of the benefits employers offer salary employees.
And this is good advice right here.
Yeah.
In writing, signature, it only protects you.
You'll be surprised. I've had a couple of cases that an employer was actually able to provide me emails and text messages from an employee that had asked for a few days off, and we were able to take those days out of their bill. That's the bona fide plan that I just mentioned. So whole day deductions may be made if an employee is absent as a result of a disciplinary suspension or violation of safety rule of major significance. So yes, you can make those deductions. Make sure you document them, because we will ask. Always document everything you do with an employee's pay. Email, anything in writing. Maybe you want to put something in writing for them to sign. Anything with their signature is gold. I cannot express that enough. Anything with their signature, we want to see when it comes to their times, their hours paid, anything like that.
And this slide notes the federal rule for ordinary
Yes.
conduct. And this one is self-explanatory.
Yeah.
Really.
A salary requirement for an exemption can be met by using the fringe benefit. Like I mentioned, they can, as long as you're taking that time out of their benefit and making sure that the salary is the same every week, it's fine. That's just a brief example. No deductions of any kind can be made of any part of the work week, absence that is what's that word? Intributable to lack of work, jury duty attendance, or judicial proceedings. So don't deduct from their salary if you're short at work.
This was covered in
Yeah.
the previous slide.
A wage is compensable for labor of services rendered by an employee. It can be determined on the basis of time, task, piece, commission, or other basis of calculation. I think that's self-explanatory. Any work that anybody does for you has to be paid. I love this. Weekly. You have to pay weekly or bi-weekly now. Right? When did that take? A couple of years.
Yeah, the ability to pay bi-weekly passed into legislation a number of years ago.
Not once a month. Weekly or bi-weekly.
Right, and we can give approval for bi-monthly. I sign, 20 or 25 of those a week, I think. They come in fast and furious. Monthly, there's a carve-out in the statute that we can consider approving for. We don't approve it. I've approved only a couple in the last few years, and those were for companies based out of Connecticut with one employee here, and typically it's a highly compensated employee who signs, a statement volunteering to do it that way.
Right. Make sure that you're paying on a pay date that's designated prior to them doing the work. No more than 8 days past the last day of the pay period. I know this is crazy, but paying in cash is not illegal as long as you document it. It can be paid with a check, or direct deposit. Payment upon termination, we get a lot of this, a lot, and you'll be surprised, this is what gets a lot of complaints in our office. So if someone voluntarily quits, right?
Yeah, so a voluntary termination, right, an employee quits, next regular payday.
Yes.
We accept a postmark.
I think to clarify, when we say payday, I think my brain goes directly to a pay period, okay? You want to pay them their last check on the next scheduled pay period. But if someone is fired, you have 24 hours or the next business day to pay them their final paycheck. That is usually when an employer will say, well, my payroll company takes a while and it's not going to work, blah, 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 blah. You can give them a personal check, company check, cash, as long as there is signatures, a receipt, something that says they got that check or that cash.
Common complaint.
Common. So much of that. Okay, so when upon termination, an employer must pay all wages conceded to be due. Release is void if wages are later found to be due.
If you know you owe the money, pay it, is really the message here.
Withholding part of wages. An employer is required or empowered to do so under state or federal law. So the only things you can deduct from an employee's pay is taxes, state and federal, FICA, garnishments, if we have approval, and any court orders, nothing else. You can't deduct anything other than those things.
Without asking for our permission, essentially, right? And that's something I handle every day, requests for all sorts of different deductions. Employers asking if they can deduct rent because the employee lives at their 3-family house. I've gotten deduction requests for electricity. Many of them are denied. A very popular and common request is when an employer wants to be able to charge an employee through their wages if they cause destruction to company property, if they break the phone, if they get into a car accident. None of those are permissible, and I deny those outright every time. And there are other ways for an employer to deal with that type of activity at work. Obviously, a very strong and robust policy, conduct policy on caring for company equipment. You have discipline that's potential. You have civil process that's available. And even given circumstances, you have criminal process that's available if you believe somebody intentionally damaged your equipment. But we just do not allow those deductions to be taken from wages that were earned.
Just to adding to that, what's common, and I'm sure you get these requests, Tom, for uniforms. Employers automatically think they can just automatically deduct from an employee's pay for this uniforms. You actually need a written permission from our office to be able to do that.
And that's a standard form on our website, in our portal.
Typical deductions that will be approved: purchase of the employer's products or services, tools, purchase of company uniforms, credit union deductions. Those are just a few of the common.
I'm sorry, Dora. If an employee buys their tools to use at work, that's fine. And if they terminate an employee and they take them, that's fine, right? Because they paid for them, and the purchase inured the benefit to the employee. Okay?
Not typically approved deductions.
And I went through some of these, maybe all of them actually.
Hey, Tom.
Yes.
I'm over here on your left. Look to your left, over here. Yeah, thanks. Just a question on that, the issue where you have damage to property and you're trying to recover. If an employee does either steal something or damage company property, can the employee and the employer agree in writing, kind of like a contract, that the employee agrees they damaged something and they will pay the employer back in installments, just not out of their paycheck, or?
Yeah, I would typically say that'd be a denial, Diane, and what I would say, and I have said to employers, that's great. Do it outside of the employee-employer pay structure. So have them pay you on payday after they cash their check.
Okay.
We don't prefer it to be from the wages that were earned.
Okay. And I'm going to pause you guys here just for a second. I want to check in with the audience and see, does anyone have any questions on something that's come up so far? Okay.
Hi, and I'm sure I know the answer to this based on what you've said so far, but we're about to start a United Way campaign at work, where United Way employees sign up to have payroll deductions, and then those deductions are sent to United Way. Is that something we need you to sign off on first?
Yep.
Yes. Thank you for the question. Those requests can be submitted right through our portal at ctdol.com, I believe it is. Yes. And look for wage and workplace standards, the tab for that.
You want to be here?
When you were talking about the time cards, the physical time cards, and a signature, if they send you an email with the punch in, punch out times from their direct email, does that still constitute a signature, even though there's not a physical signature?
Yes, as long as you can prove that it was coming from that employee, and the email is very clear in the date, time, okay?
So the Connecticut paid leave benefits, I assume we're not allowed to pay more than 100%, so is that deduction automatic because that's a law?
Right, that's in accordance with law, and our division doesn't really touch that. That's the Connecticut Paid Authority that manages that process. Yes, yes. I'll be honest with you, it comes out of my paycheck, and I never signed giving permission, so, yeah, no, that's permissible, yeah.
Okay, I've got a question here.
Hi. If we have a form that the employee gives us approval to deduct something, is that enough? Or, for instance, 401k deductions is one. We're looking into possibly a food program, providing food. The employees would pay a part. Is that something that needs Department of Labor approval first?
Yes.
Yes, because it's not captured in the statute. There are a limited number of deductions captured in the statute that you don't need to talk to us about. FICA, federal tax, garnishments, court decisions. And I don't want to sound negative about the deduction requests. We approve many, and there are all sorts of them. Please submit it and we'll consider it.
Thank you.
So I have a question. What about things that are governed by a collective bargaining agreement?
That's a very good question. No, it's very good. We try to stay away from collective bargaining agreements that were mutually agreed to right by labor and management. No, I would defer to whatever is in a CBA as long as it was mutually agreed to, right, and bargained.
Okay. Go ahead.
I'm going to go back to the Connecticut paid leave question again, because I think the question wasn't understood correctly. So if we expect our employee, or we know that our employee is receiving benefits from the state, can we automatically deduct that amount from what we are paying them so that they are not receiving more than 100% of their pay? Or do we have to get permission from your department?
You've posed a question I am not prepared to answer in the interest of full transparency. How about we connect after this, and we'll exchange contact information. I'll get you the answer.
Great, thank you.
Okay, there's one.
This is a really specific question, so I'm not sure if you could answer it. But a company I previously worked for, they had an employee who had an issue in one department and transferred them to another within the same store. somehow, upon doing that, they terminated the employee in the system and paid out all their PTO without the employee's knowledge. And all that PTO was then taxed and put into their account, but the paper checks were still given to the employee, and that's how the employee found out that she was technically terminated. But then, to get the PTO back, they took wages from her paycheck every week to put that money back. Is that legal?
Wow.
I may have been the employee who they did this to.
That's complicated.
What's the name of the employer?
Why don't we, no, we can talk about PTO in general, but we encourage people to file claims with us. But Dora can talk about PTO just in general.
So, any benefit in time that you offer an employee, right? That's a benefit. It's not required by our laws to give someone a vacation or personal time off or anything like that. So we generally refer to the employer's policies on that, on how that's paid out at time of termination. Some employers will say, you get zero. You're going to get nothing if you don't give me 2 weeks notice. Or if you simply just leave, you're not getting anything that's been accumulated, right? But if the employer lacks those details in their policy, then it opens the door for us to come in and make a determination on whether it should be paid or not, based on past experiences with other employees in the same situation. We will look at that. But keep in mind, and this is what we tell a lot of the claimants that file complaints regarding benefits, we don't always have the jurisdiction to collect that. So we will always just lean a lot on the policy of the employer and past practice. And to answer your question, if the employer wants to take back whether it's PTO or anything, let's say they overpay someone, okay? If someone gets overpaid an extra, I don't know, $100 a week, and the employer did that by mistake, but the employee never even realized it or just took it, most likely, we have allowed the employer to deduct it in the same way it was given.
No, I think these are questions I get at times, and school districts, municipalities, the state of Connecticut as employers happens. It happens. It's human error most of the time. And Dora's right. We don't enforce the recovery of overpayments, but we potentially could if you tried to deduct, let's say, $6,000 all in one shot that had been accidentally deducted for 6 months, in increments. We would try to impose our authority on.
Right, and then, and this is where the problem comes in. Let's say that employee that owes you $6,000 decides to leave tomorrow. You're not going to withhold their last paycheck on that. You're not going to say, hey, you owe me $6,000, I'm keeping your last check that's for $2,000. That's not going to happen because we will never allow that. We have allowed employers, if they have something in writing, to take back whatever error happened in the payroll, as long as there's an agreement between the employer and the employee and it's done in writing. And it shows that the deductions taken back is in the same way it was originally done. So if it's done once a week for $100, we will expect that to be taken back $100 a week. Does that make sense? Does that answer your question?
And PTO is compensation, right? So the taxes are going to be involved in that payment process.
Hi, I have a question going back to the jury duty. I want to make sure our policy is correct. Per this, I can't take any deductions, so we just updated the policy, but it used to be we used to give 3 days for jury duty, so it's unlimited because you can't deduct. Does that question make sense?
Well, you're paying them for jury duty, correct?
Correct, but if the jury duty went over, because we've updated the policy, went over 3 days, then they didn't get paid.
have to double check that. Let me get back to you on an answer with that.
Awesome, thank you.
I've got a question about breaks. We talked about punching in, punching out 4 times. Do employees need to punch out during a break and then punch back in?
Breaks, you're not referring to lunch periods, correct?
Correct, just
Regular,
15-minute
15-minute
breaks,
break?
yeah.
No, because you're not deducting that time from their work time. So
okay.
you cannot deduct anything that's less than 20 minutes.
Okay, we've got a question here.
For salaried employees that are getting paid their regular salary but are working on other contracts, per se, a contract that requires us to do a video for 8 hours. If the employee works more than the 8 hours, even though they were told that there was only 8 hours to be paid, do we have to pay them?
Okay, so is this a salary employee or an
Yes.
hourly employee?
A salaried employee getting their regular paycheck but working on another contract where we only got paid for 8 hours of work.
So regardless of how the company is paid, that's separate. We will always look at what your agreement is to pay this employee, okay? So just because the company is not getting paid over the 8 hours, that doesn't mean that you don't get to pay the employee over the 8 hours.
But if we told the employee that they only had 8 hours to work on it, no? Okay.
Nope.
Thank you.
Yep.
Yes, I have a two-part question, actually. The first one is, if an employee consistently doesn't punch in and out, and I'm sure it should go in the handbook, whether there's any disciplinary action, but let's say they only punched in one day. I mean, if it was up to me, I'd pay them one day and call it a day. But, I mean,
You're not alone on
what
that.
do we do?
I want to work with you. Listen, this comes up especially with meal periods. Discipline. I met with an employer a few weeks ago, and he was at his wit's end. There's a lot of employees at different places. He says they just won't punch out for the meal period. And we said, discipline them. Now, I'm not talking terminal, I'm saying progressively, right?
Right.
Based on whatever the violation is. But if that's the only way, then that's the only way.
Okay.
Yeah, because
And-
obviously it's on the employer.
Huh?
It's on the employer. The
Right.
responsibility is on.
True.
Let's put it this
True.
way.
Put it
If-
on them.
If I look at those records, and let's say you were getting audited, and I look at those records and the punches are missing, that's a $300 fine that you're getting for that employee not having those proper punching in and outs. So you're gonna have to be the bad guy and discipline your employee.
Okay. And then the second question is there anything in the state of Connecticut that says there's an annual limit for part-time workers?
Not in Connecticut state labor law.
We don't distinguish between a part-time and a full-time.
Okay.
Yeah, if you look at our laws, it won't say full-time or part-time employees.
Okay, thank you.
I've got a question about, this is an online question. Our PTO policy allows employees to take PTO in advance. If they have a negative PTO balance at the time of their termination, can the employer withhold PTO already paid from their final paycheck?
The answer is yes with our approval, and I would encourage the person to submit a request to us through our portal. Those I approve regularly.
Okay, anybody else? Okay, Philip, you run down that way, I'll go this way.
So I had heard you mention about what's allowed for deductions, and I thought there's a list in here, but typically most employers deduct for, besides health insurance, retirement accounts, union dues, even like if you have to pay for family, for someone who may have to care for a child in maybe another state or something. Those have to go to you each time for approval or approval initially, or because
No, if there's a provision in the CBA that requires a deduction, that does not need to come to us.
so retirement accounts and things like that, those are allowed?
No, sir.
Okay.
That
I
doesn't
thought
require approval.
okay, I might have misunderstood that. Thank you.
What if an employee leaves at the beginning of the month and they have benefit coverage through the end of the month? Are we allowed to deduct prorated premiums? Like what they would have paid had they stayed through the month?
Are they still covered?
They're still covered through the end of the month.
Then I would say yes.
Fantastic.
Hi. I know salaried exempt employees are paid for a day's worth of work if they show up, right? And they did work for a couple hours, example. But if we have a PTO policy in place that says that salary employees can take half-day increments, is that allowable?
Yeah, so if the person is only physically working for half a day and they want to use the rest of the half a day with their any benefit time, yes, that's allowable.
Okay, thank you.
All right, we've got time for maybe one. Oh, lucky in pink. Okay, we've got time for one more.
Hi. If an employee accrues 3 weeks, a salary employee, I'm sorry, has 3 weeks of vacation, and they've used it by September, but then they continue to take time off, we have to pay them?
Not if they're not, if once they've exhausted all their benefit time, then you can start making deductions.
Okay. Yes. Good question. It's very common. All right, we are out of time. But thank you very much, Tom and Dora. I know you didn't get through your slides. Sorry.
Thank you.
Thank you.